The Law on Obligations and Contracts. This subject introduces the students to the legal basic concepts related to obligations and contracts. It will cover the general principles of obligations and contracts, the various classifications and kinds thereof, its nature and effect, the modes of extinguishing the obligations, the form of contracts and the remedy of reformation, as well as the rules of interpretation. At the end of the chapter, the students will be able to enumerate and identify the basic concepts of law as to its definition, general and specific classifications, and the sources of laws. The requirements of this course include the following: periodical examination for the first semester, prelims, midterms and finals, assignments, online quizzes, research work, uploaded comments on the Facebook group. We move on to the introduction to law. Law is generally defined as any rule of conduct. It prescribes a mode of behavior as a particular sector of society at a given time and place. It is a system of uniformity. Everywhere you go, you can find the application of law. For example, during this pandemic, we are all required to wear face masks and even face shields. These masks and face shields were never required before the pandemic, but now, everyone is required to comply. Here is another example of a rule on conduct. When you are participating in video conferences, one of the house rules or ground rules prescribed is for participants to mute their microphones unless they are given the chance to speak. Can you imagine the chaos it will bring when all microphones are turned on at the same time and everyone speaks all at once? It surely will be irritating and problematic. Hence, we can say that observance of the prescribed rules of conduct works to maintain social order. The general classifications of laws include state laws and non-state laws. Let's tackle the non-state laws first. From its name, these are laws that are not created by the state or by the government. Nevertheless, they prescribe rules of behavior as we interact with the people around us. The non-state laws include the following: divine law, natural law, moral law and physical law. Divine law comprises the body of law that is perceived as deriving from a transcendent source, such as the will of God or gods. In contrast to man-made law or to secular law, it may refer to a commandment from any religion. It is considered divine law because its origin and authority is divine. Here's some questions you can think about. What are some commandments of a deity or of your religion are you familiar with? Now what happens when you violate that divine law? Do you get arrested by the police and be put in jail? The next kind of non-state law is natural law. In philosophy, natural law is a system of right or justice held to be common to all humans and derived from nature rather than from the rules of society. Or positive law. The theory of natural law says that humans possess an intrinsic sense of right and wrong that governs our reasoning and behavior. The concepts of natural law are ancient, stemming from the times of Plato and Aristotle. Natural law is constant throughout time and across the globe because it is based on human nature, not on culture or customs. Natural connotes that something is innate or inborn. As human beings, there is something inside us that tells us what is right and what is wrong. Even if we do not study law formally, there is that prompting within us that tells us or gives us sense of right and wrong. Do you know what it is called? Remember Pinocchio? He was not a real boy, not a natural one. The fairy godmother gave him an external guide to remind him if he is saying the truth or not. Here's a trivia. The Pinocchio syndrome is basically a compulsion to lie, a habit so ingrained that it can convince even the most sensitive people. The allusion to the Pinocchio character is well deserved, although, unfortunately, does not denote the growth of the nose. If the nose really grows every time a person lies, would you lie too? Here's a challenge. Young as you are, fortify your natural law. You know that cheating is wrong, in whatever form. Copying the work of your classmate is cheating, whether that work merits 5 points or 500 points. As Dr. Jose Rizal said, the young people are the hope of this motherland. If you cheat in small things, what makes you think you will not cheat in bigger things? So if you cheat now and then you become the president of our country in the future, do you think you will not cheat? The third kind of non-state law is the moral law. It is a system of guidelines for behavior. These guidelines may or may not be part of a religion, codified in written form, or legally enforceable. It is relative in nature as some societies have defined acceptable behavior which may be looked down upon by other sectors. In other words, what may be morally acceptable in one place at a certain time might not be acceptable in another place or at another time in the following situations. Do you think the act is illegal or legal? Is it morally correct or not? Situation number 1. Breaking a promise to a friend. Situation number 2. Using abortion as a birth control measure. Situation number 3. Tax avoidance situation number 4. Same-sex marriage situation number 5. Use of marijuana for medical purposes. As you ponder your answer to the question with respect to the sample situations, try to analyze too the standard you used in saying the act is moral or immoral, legal or illegal. Sometimes we fall into the trap of being holier than the people around us and we become too judgmental, more often than not, without basis. The last kind of non-state law is physical law. This is also known as scientific law, or a law of nature is a scientific generalization based on empirical observations of physical behavior. Empirical laws are typically conclusions based on repeated scientific experiments over many years, and which have become accepted universally within the scientific community. For example, we know that what goes up must come down. What law would explain that? What about the rule that opposites attract? What is the basis of that generalization? Let's now go to the state laws. A state law has the following characteristics. A state law is a set of rules. A state law regulates the human conduct. A state law is created and maintained by the state. A state law has certain amount of stability, fixity and uniformity. A state law is backed by coercive authority. A state law, when violated, leads to punishment. A state law is the expression of the will of the people and is generally written down to give it definiteness. A state law is related to the concept of sovereignty, which is the most important element of state. Some authors would say that state law has 4 characteristics. It is a rule of conduct. It is obligatory as it imposes a duty to obey. It is promulgated by legitimate authority. And it is of common observance and benefit. It is territorial in nature. In the Philippines, all those within the Philippine archipelago are affected by our state laws. As state laws are obligatory, the lack of knowledge of such laws will not excuse anyone from complying. Everyone is presumed to know the law as it is a citizen's obligation to know the law. Hence, the following principles are noteworthy. 1. Ignorantia legis non excusat, which means ignorance of the law excuses not. 2. Ignorantia legis neminem excusat, which means ignorance of law excuses no one. 3. Nemo sensitor ignora legem, which means nobody is thought to be ignorant of the law. 4. Ignorantia iuris noce, which means not knowing the law is harmful. These are legal principles holding that a person who is unaware of a law may not escape liability for violating that law merely because one was unaware of its content. Further, even if the law imposes difficulty, a person affected should still follow it unless he is prepared to suffer the consequences of disobedience. The principle of dura lex sed lex applies. The law is harsh, but it is the law. It follows from the principle of the rule of law that even draconian laws must be followed and enforced. If one disagrees with the result, one must seek to change the law. There are various kinds of state laws which include the following. 1. As to purpose, we have the substantive law which creates and defines the rights and duties of individuals. An example of this is the law on obligations and contracts. 2. As to purpose, we have the adjective law or remedial law or procedural law which prescribes the manner or procedure by which rights and obligations may be enforced. An example would be the rules of court. 3. As to subject matter, we have public law which regulates the rights and duties arising from the relationship of the state to the people. Examples of this would include the following. Criminal law which defines crimes and provides for its punishment. International law which governs relations among nations. Constitutional law which establishes the fundamental powers of the state and fundamental rights of the people. We also have private law which regulates the relations of individuals with one another purely for private ends. Examples of private laws include the following. 1. Civil law, which is a body of rules that defines and protects the private rights of citizens, offers legal remedies that may be sought in a dispute, and covers areas of law such as contracts, torts, property and family law. 2. Commercial law or mercantile law or business law or trade law, which is the body of law that applies to the rights, relations, and conduct of persons and businesses engaged in commerce, merchandising, trade, and sales. 3. Labor law, which governs employment practices and labor relations. 4. International private law or private international law is a set of rules of procedural law that regulates the relationships between physical and judicial persons of different nationalities. Let's now go to the sources of law. The main sources of Philippine laws are: the first source of Philippine laws is the Constitution, which is the fundamental and supreme law of the land. Do you know what your fundamental rights are under the Bill of Rights? The next source of Philippine laws are the legislations or statutes which are enacted by the lawmaking branch of the government. Another source of Philippine laws are the administrative rules and regulations, which includes the implementing rules and guidelines issued by the executive branch of the government. Another source of Philippine laws are the judicial decisions of the Supreme Court of the Philippines, otherwise known as jurisprudence. Article 8 of the Civil Code provides that judicial decisions applying to or interpreting the laws or the Constitution shall form a part of the legal system of the Philippines. In relation to this, the following legal doctrines are to be noted. 1. Stare decisis is a legal doctrine that obligates courts to follow historical cases when making a ruling on a similar case. This doctrine ensures that cases with similar scenarios and facts are approached in the same way. 2. The doctrine of stare decisis, et non quidem avere. Simply put, it binds courts to follow legal precedents set by previous decisions by the Supreme Court. Another source of Philippine laws is the treaty, which is also known as an international agreement, protocol, covenant, convention, pact, or exchange of letters, among other terms, and is formal written agreement entered into by actors in international law, namely sovereign states and international organizations. Other sources of Philippine laws are the customs or customary laws, as they also form part of the Filipino legal system. Article 6, Paragraph 2 of the Constitution provides that the state shall recognize, respect, and protect the rights of indigenous cultural communities to preserve and develop their cultures, traditions and institutions. The primary sources of Muslim law or Sharia are the Quran, Sunnah, Ijma and Qiyas. Other sources of laws may include religion, decisions of foreign tribunals, legal opinion of law textbook writers or legal luminaries, and the principle of justice and equity. In the Philippine context, there are three branches of the government as follows. 1. The legislative branch of the government, comprising of the lower house where the congressmen are, and the upper house composed of the 24 senators. 2. The executive branch, which implements the laws, is composed of the office of the president and all attached administrative and regulatory agencies. 3. The judicial branch, comprising of the different courts. Each city and municipality in the Philippines has its own trial court. These first-level courts are more commonly referred to as Metropolitan Trial Courts, METC, Municipal Trial Courts in cities, MTCC, Municipal Trial Court, MTC, and Municipal Circuit Trial Courts, MCTC. The METCs are the first-level courts in the Metropolitan Manila area. First-level courts in cities outside Metropolitan Manila are referred to as the MTCCs. The MTCs are first-level courts that cover only one municipality, whereas MCTCs cover multiple municipalities. Regional trial courts are also known as second-level courts, which were established among the 13 judicial regions in the Philippines, consisting of regions I to 12 and the National Capital Region, NCR. There are as many regional trial courts in each region as the law mandates. RTCs were formerly called as the Court of First Instance since the Spanish era. It was only in the Judiciary Reorganization Act of 1980 that its name was changed from being called the Court of First Instance to Regional Trial Court. The Sharia district courts are equivalent to the regional trial courts in rank, which were established in certain provinces in Mindanao where the Muslim Code on Personal Laws is being enforced. On the other hand, the Sharia circuit courts are the counterpart of the municipal circuit trial courts established in certain municipalities in Mindanao. Both the 1973 and 1987 Constitution contain provisions on the present anti-graft court known as the Sandiganbayan. It has jurisdiction over criminal and civil cases involving graft and corrupt practices and such other offenses committed by public officers and employees, including those in government-owned or controlled corporations, in relation to their offices may be determined by law. The jurisdiction of the Sandiganbayan is perhaps one of the most often amended provision from the 1973 Constitution to Republic Act No. 8249. Before R.A. No. 8249. Jurisdiction of the Sandiganbayan was determined on the basis of the penalty imposable on the offense charged. Thereafter, it was amended such that regardless of the penalty, so long as the offense charged was committed by a public officer, the Sandiganbayan was vested with jurisdiction. Under R.A. No. 8249, to determine whether the Sandiganbayan has jurisdiction, a person must look into two criteria, namely, the nature of the offense and the salary grade of the public official. The Court of Tax Appeals, CTA, was created on June 16, 1954, through the enactment of Republic Act No. 1125. Its jurisdiction and composition have been increased with passage of several legislations. With the enactment of Republic Act 9282 on April 23, 2004, the CTA became an appellate court, equal in rank to the Court of Appeals. The composition of the court increased to 6 justices with 1 presiding justice and 5 associate justices. R.A. Number 9503 took effect on July 5, 2008, which further enlarged the organizational structure of the CTA. The CTA is now composed of 1 presiding justice and 8 associate justices. The CTA may sit en banc or in 3 divisions, with each division consisting of 3 justices. A decision of a division of the CTA may be appealed to the CTA en banc, and the latter's decision may further be appealed by verified petition for certiorari to the Supreme Court. The Court of Appeals was established on February 1, 1936 by virtue of Commonwealth Act No. 3 and is considered as the second highest tribunal in the country. It is composed of 1 presiding justice and 68 associate justices, all of which are appointed by the President from a shortlist submitted by the Judicial and Bar Council. The associate justices shall have precedence according to the dates or order, in case of similar appointment dates, of their respective appointments. The qualifications for the justices of the Supreme Court also apply to members of the Court of Appeals. The Court of Appeals' principal mandate is to exercise appellate jurisdiction on all cases not falling within the original and exclusive jurisdiction of the Supreme Court. Its decisions are final except when appealed to the Supreme Court on questions of law. The jurisdiction of the Court of Appeals are as follows. 1. Original jurisdiction to issue writs of mandamus, prohibition, certiorari, habeas corpus, and quo warranto, and auxiliary writs or processes, whether or not in aid of its appellate jurisdiction. 2. Exclusive original jurisdiction over actions for annulment of judgments of regional trial courts. 3. Exclusive appellate jurisdiction over all final judgments, resolutions, orders or awards of regional trial courts and quasi-judicial agencies, instrumentalities, boards or commission. The Court of Appeals shall also have the power to try cases and conduct hearings, receive evidence and perform acts necessary to resolve factual issues raised in cases falling within its original and appellate jurisdiction, including the power to grant and conduct new trials or proceedings. The Supreme Court has both original and appellate jurisdiction. It exercises original jurisdiction, which means cases are directly filed with the Supreme Court in the first instance without passing through any of the lower courts, over cases affecting ambassadors, other public ministers and consuls, and over petitions for certiorari, prohibition, mandamus, quo warranto, and habeas corpus. It also has original jurisdiction over writs of amparo, habeas data, and the environmental writ of calicazon. It exercises appellate jurisdiction to review, revise, reverse, modify, or affirm final judgments and orders of the lower courts in 1. All cases in which the constitutionality or validity of any treaty, international or executive agreement, law, presidential decree, proclamation, order, instruction, ordinance, or regulation is in question. 2. All cases involving the legality of any tax, impost, assessment, or toll, or any penalty imposed in relation thereto. 3. All cases in which the jurisdiction of any lower court is in issue. 4. All criminal cases in which the penalty imposed is reclusion perpetua or higher. 5. All cases in which only an error or question of law is involved. The Supreme Court has administrative supervision over all courts and court personnel. It exercises this power through the office of the court administrator. Here are some points to ponder. 1. What are the components of each of the 3 branches of the government? 2. How does each branch contribute to the laws of the state? 3. What are your constitutional rights? 4. What are the different courts in the Philippines? 5. How is law applied as a means of social control in your relationship with family, friends, classmates and teachers? 6. What are the penalties in the Philippines?